Good morning, everyone. Thank you so much for joining today. I am Candice Gomez. I'm a law partner in our Long Island office, and I'm very happy to be with you this morning to discuss School Law 101, use of school facilities, leases, and licenses. You'll see that during this presentation, we will be talking about the leasing of real property, but I do want to make a note that if you have an interest in licenses when it comes to intellectual property, copyright, trademark issues, those types of matters. We had an awesome presentation that was done a couple of months ago by our law partner, Fred Price, and that is available in the client-only portion of our website. We have all of these School Law 101 programs archived so that you can go back and look at them at your convenience if you need to kind of refresh your memory on anything, or maybe you couldn't attend one and you wanted to catch up on something that you missed. It's available there. So for those with an interest in intellectual property licenses, we do have that available for you. Really glad to have a great group here today. We have a lot of materials to cover, so I do not know if I'll be able to get to all of the questions. I will try to periodically check the chat in the Q&A as we go through this to see if there are questions that have come in. If I do not have a chance to address your question during this webinar, please feel to email me. All of my information is on the bond website, and we will follow up with you. So thank you again. And with that, let's go ahead and get started. If we could move to the next slide, please, Sophie. Wonderful. Great. So when it comes to the use of school facilities, this really all stems from a very important portion of the New York State education law, which is Section 414. That section of the Ed law provides the legal authority pursuant to which school districts are authorized to permit outside organizations to use school facilities. So I know that you're all familiar with the process for outside organizations trying to use school facilities for various purposes, whether it happens to be a dance group that wants to use your school gym for practices, or maybe it's an athletic group. In many of our districts, there's a policy 1500 that deals with this. Your policy number may be different, but we all have the policies that govern the use of school facilities, and it all stems from this Ed Law Section 414 that I mentioned. Next slide, please. Education Law 414 provides a list of the general categories of activities for which boards of education are explicitly authorized to allow non-school organizations to use school facilities. So we have many internal school organizations, of course, that use our school facilities for various purposes. But when a school district is going to be allowed to use school facilities and they're an outside organization, we have to abide by certain rules, and those rules are subject to change by an individual board of education. For example, all of the categories that are allowable pursuant to Ed Law 414, and we'll go through those categories in a moment, do not necessarily need to be permitted by your particular school district. So let's go through some of the categories so that I can provide a better description of what I mean by that. Next slide, please. And again, before we get to those categories, the baseline is that these school facilities can only be used by outside organizations when it is not going to be disruptive to the normal school operations. So your normal school operations, your internal clubs and organizations, that should be primary in terms of using those school facilities. But to the extent that you have a cafeteria, a gymnasium, a classroom that is not being used for normal school operations, in circumstances such as that, you may be able to allow outside organizations to use those facilities within the parameters that we're going through now. Next slide, please. The first is if it's for the purpose of instruction in any branch of education, learning, or the arts. So I mentioned the dance group. That would qualify as instruction in the arts. That would be an allowable use pursuant to 414. A public library use. If you are holding or this outside organization is holding a social, civic, or recreational meeting, or some form of entertainment, that may also be an allowable use. And civic meetings do include, but are not limited to, of course, meetings of parent associations and PTA associations. So those certainly are allowable, permissible uses under 414. Next slide, please. The school district may also allow an outside organization to use school facilities for meetings, entertainment, and occasions where admission fees are charged and when the proceeds thereof are to be expended for an educational or charitable purpose. We're going to spend some time in the upcoming slides talking more about what that means because we frequently get questions about when a school district can allow a for-profit organization to come in, hold an event, perhaps charge an admission fee or some type of ticket fee, and whether or not that is okay to do. So we'll spend some more time speaking about that because that does tend to be an area of more questions and bigger concern. But I would like to point out that, as I mentioned before, even though 414 provides kind of the outer limits here, an individual school district may choose to shrink those limits, meaning you don't necessarily have to allow an outside organization that is charging a fee to use your space if your board policy provides that that is not something that you want to do. So, for example, if your board policy says that you only want to allow nonprofit organizations to come in and use your school facility, you can do that as long as you're doing it on an equitable basis, meaning that you're not picking and choosing any organization that is not a non-for-profit, meaning that it is a for-profit organization would need to be excluded equally as opposed to the school district just choosing certain organizations that it may like. Another category that school facilities may be used for is for polling places, for holding primaries and elections, and for the registration of voters and holding certain political meetings. So we know that school facilities are frequently used when, let's say, there's a county election, or even if there is some type of presidential election, one of the more national elections. That is an allowable use of the school facilities if it's going to be used for a polling place. A school district facility may also be used for certain civic forums and community centers. Next slide, please. It may be used for classes of instruction for minors with developmental disabilities that's operated by a private organization that's approved by the commissioner. So I just want to highlight here that this doesn't necessarily mean all private organizations. So if your policy says that you're only allowing not-for-profits, then this is one that you would want to look at because there are certain private organizations that may be um, for-profit that would not be allowed. But if it's a private organizations that are approved by the commissioner, we may be in a slightly different category. That's not something that comes up very often, but I'm just flagging it for your notes there. The school facilities may be used for recreation, physical training, and athletics. We know that this often happens. The local youth association is going to use your gymnasium or your fields. That happens very often. School facilities may be used to provide childcare services during non-school hours. So we have the frequent before school and after school programs that are provided within the school buildings. There are many different programs that operate. I won't name them, but I'm sure you're familiar with some of the more popular and more widely used organizations. They may all be permitted to use school facilities. And we'll talk about how that happens and making sure that we have appropriate insurance and all of the safeguards to ensure that it's done properly. Because although they're allowed to use school facilities, we still, of course, have a responsibility to make sure that they're using it in a responsible way that's not going to incur unnecessary liability or risk to the school district. Next slide, please. So licensed school-based health, dental, or mental health clinics. We've seen certainly an increase in these school-based health organizations within the school district building over time. So this is an area of kind of growing popularity, let's say, and we found that it has been very successful for many school districts. It is an allowable use, and again, we just need to make sure there are certain safeguards in terms of who is operating these organizations and separating the health purpose from the school district purpose. One example that we can mention now is the records and making sure that there's some type of real system of having almost a screening between the records that are held by that school-based health organization and the general records. There may be HIPAA concerns that don't apply in the normal school setting with the school nurse, for example, that may apply to some of these health clinics. So when it comes to making sure that information remains confidential and that things are handled properly, we do want to continue to think about these as separate facilities as opposed to just kind of whole cloth being incorporated into our school district and assuming that it follows all of the same rules and procedures of a school district because there may be additional restrictions and requirements regarding those health clinics. And the last category that we'll talk about here is for graduation exercises that are held by not-for-profit elementary and secondary schools as long as no religious service is performed. We'll talk more about how the religious aspect of use of school facilities comes into play. That is a changing landscape. We're seeing more of a leaning both within the courts and perhaps even, in the court of public opinion, so to speak, in terms of allowing the use of school facilities for religious purposes. And we'll talk about some court cases that show us kind of the progression in terms of some of that being more allowable than others. But the statute, as of now, in 414, does state that those graduation services should not be used for a religious service. Now, to the extent that someone may say a quick prayer in the beginning or say something that is of a religious nature, it's debatable as to whether or not that's a religious service. It's not necessarily going to count as a religious service or a worship service if it's kind of an offhand sentence or two, but that is something that we should keep in mind before we allow graduation exercises to be held by outside organizations. Next slide, please. Let's go back to the use of school facilities when admission fees are being charged. So we talked about that category of Ed Law 414 that allows for the use of school facilities for meetings, entertainment, and occasions where admission fees are charged and when the proceeds thereof are to be expended for an educational or charitable purpose. So let's break that down a little bit to see what this actually means. If an outside group, let's just call them ABC organization, wants to come in and use the school facilities, they are a for-profit entity, and they're saying, okay, school district, we have filled out your use of facilities form, we have the necessary insurance, we have provided you with the appropriate fee to use, let's say your cafeteria to hold this event. By the way, we're going to be charging guests a $20 admission fee when they come in. Um, is that something that's okay? Let's walk through a scenario like that. Next slide, please. Okay, great. So 414 requires that the proceeds from admission fees that are collected by outside organizations while using the district's facilities must be expended, meaning they must be used for an educational or charitable purpose. But the law does not specify that the organization that collects the admission fees must itself be organized as an educational or charitable organization. So if we follow that line of thinking, it's not unlawful for a for-profit entity, an entity that is in the business of making money, to charge an admission fee while using the district's facilities, provided as long as those proceeds from the admission fees that are collected are used for an educational or charitable purpose. So just being a for-profit organization alone doesn't mean that they should be excluded, but those admission fees should be used for an educational or charitable purpose. Next slide, please. An educational or charitable purpose, of course, the next question that you may be wondering is, what is that exactly? What specifically are we talking about? What do they need to spend that money on that would qualify as an appropriate use of educational or charitable purposes. And frankly, it's not defined in Ed Law 414. Again, that's kind of the wellspring, the source of which we're getting this information. And it's also not clearly defined in the law that interprets 414, but we're able to glean from other sections of the law and from Commissioner of Education decisions what this most likely means. So if we look at other areas of the law that describe the activities of a not-for-profit organization, we can get a better understanding of this. New York State's Commissioner of Education has ruled in other contexts that boards of education may not permit the use of school personnel or facilities for the conduct of a private business. We see here that this matter of Gordon case is cited there, and that case deals with a situation in which a school district was allowing a private business that provided a service in terms of music instruction. So individuals from this private company would come into the school building, provide music lessons to the students before school or after school. Parents were being charged a separate fee for their children to get music lessons in the school building on school property by this private organization. The money was going directly to the private organization. And the commissioner ruled that that really was not appropriate because the school board should not be using school facilities for the conduct of a private business. So all of the money that was being gained from that was going directly back into the business. It wasn't being used for an educational or charitable purpose in the context of which 414 was devised. So based on that, oh, if we could go back, um, it's appropriate to cautiously interpret the words for an educational or charitable purpose in 414 to mean that this for-profit organization is using it to fund nonprofit educational or charitable purposes. So maybe this organization has a foundation that's nonprofit that they then funnel that money towards, or maybe they donate it to a nonprofit educational or charitable organization once they receive that money in those ticket uh, proceeds, and that would be permissible. Next slide, please. Use of school facilities for religious purposes. So we kind of touched on this, and I do want to spend a moment talking about this here because we see that the landscape is changing a bit, and this is an area where if you get questions about it, you'll want to reach out to the school attorney that you normally are in contact with, just to make sure that you are kind of handling this as prudently as possible. Because when you're kind of standing on shifting sands, as they say, you want to make sure that you have another set of eyes and ears reviewing what's happening. So the Bronx household case was a situation in which 2014, the Second Circuit, which is the circuit court that has jurisdiction over New York State, upheld a school district regulation that precluded, that did not allow the use of school facilities for religious worship services. In that case, the school district had a policy that allowed for the use of school facilities outside of school hours by outside organizations and individuals. However, when outside organizations and individuals were using the school building, the school district policy said that no permit would be granted for the purpose of holding religious worship services or otherwise using the school as a house of worship. So they're basically saying you can use it, but you cannot have prayer services here. You can't hold your weekly church meetings here. You can't have your weekly Bible study meetings here. To the extent that there may be kind of tangential religious references, perhaps the school district would have allowed it. But when we're talking about specific religious worship, they said, no, we're not going to allow it pursuant to our policy. And this went back and forth in the lower courts, but on appeal, the U.S. Court of Appeals ultimately found that the school district was okay in the sense that it was not required to um, finance subjects' exercise of religion, meaning they were not required to allow their school building to be used for worship if their board policy stated as such. The court did not find that there was evidence that the school policy was motivated by any hostility towards religion, but that they simply wanted to have some type of separation of the religious worship from the secular education. Separation of church and state is the kind of easy go-to phrase that many of us know. And the court did not find that the school district was wrong in going about that through a board policy. I will note, however, that if your board policy does not state that it has a prohibition that it will not allow worship services, then you should be treating your request for use of facilities from churches, from synagogues, from mosques, from any religious organization the same way that you would treat requests from other organizations. So, in other words, if you don't have this carve out here, then if you get a request to use your facilities for religious or worship services, that is something that would be permissible. And we'll look at the Bremerton case now. And of course, one caveat that I want to mention here is it must be clear that this is not something that school endorsed and that the school is not promoting any particular religion, that it is simply being done through an equitable kind of doling out of the school facilities. And of course, if you allow one religious group to use the school facilities, you cannot pick and choose and deny another religious group the opportunity to use the facilities, assuming that those facilities are available and they otherwise would have the opportunity to use it. So it has to be done on an equal footing, equal basis. Let's spend a moment looking at the Bremerton case now. If we could go to the next slide. I think it may actually be the Kennedy case. Let's move on. Sophie, thank you so much. So Kennedy versus Bremerton School District. This I'm mentioning not really because it is a use of school facilities case, but because that wasn't the main issue in this case. The main issue in this case was about employee speech. But I do think it's interesting, and I think it's worth noting that the speech that was allegedly happening was on school property. And it gives us an indication of how the law seems to be kind of evolving in the sense that more and more religious speech, more and more religious use is being allowed on school grounds. In 2022, the U.S. Supreme Court ruled that a school district in Washington violated the constitutional rights of a high school football coach whose name was Kennedy by disciplining him when he was kneeling at midfield. So this is happening on the football field. This is on school grounds after games to offer a quiet prayer of thanks. And they found that he should have been able to do that. Now, the dissenting Supreme Court justices, those justices that did not agree with the opinion, thought that this was a problem because he was inviting other players, other students to join him in prayer on school grounds. This wasn't an outside organization, so it was clearly kind of under the auspices of the school district. And they found that that was a form of indoctrination. However, the majority did not agree with the dissent, and they said this coach has the right to pray at midfield on school grounds if he chooses. If other students, other people want to join him in that prayer, they have the right to do so, and we should allow it to move forward. So again, let's just be a bit cautious when it comes to use of facilities applications for religious purposes and check in with us regarding that as needed. Next slide, please. Awesome. Leasing school district property. The education law permits school districts to lease real property that is not currently needed for school district purposes. So if you have kind of a decrease in enrollment, as many school districts do, and there's a certain school building that you frankly don't need to use as much for school purposes, you may want to think about leasing that building to another entity. It could be a good form of recouping some revenue that you could use for other purposes, funds that you could use for other purposes within the school districts. But we cannot do that, of course, without rules and regulations. So, first of all, the lease may not exceed 10 years. A lease that does not exceed 10 years does not require voter approval and may be authorized by a simple board resolution. So, a board can decide to lease property to an outside organization without going to the voters during that annual meeting in which we have propositions for various purposes, the budget, school board members, you may have a sale of property. It doesn't need to happen in that way during an annual meeting as long as it does not exceed 10 years. And of course, the board has a fiduciary obligation to secure fair market value as determined by the Board of Education for the rental. So to the extent that this board is going to allow an outside organization to rent, to lease some of your school facilities, you should be getting the best value for it, fair market value that you can, so that of course it's to the benefit of the taxpayers that are funding the different district facilities. This requirement has been interpreted by the courts to mean that the Board of Education may not ignore the monetary offers of a party that is looking to lease your property, but also we should keep in mind that the amount of money does not need to be the sole basis for the board's decision when they're deciding whether to lease to one organization or another. So if the board has offers to have organization A and organization B lease a school building, perhaps organization A is offering more money, that doesn't necessarily mean that the board has to allow organization A to use the facilities. If organization B has other factors that make you believe that they could be a better option, then you are allowed to go ahead and consider those factors and perhaps choose organization B if it makes sense. Some of those factors may be that they have leased property in the district before and they've been responsible tenants, or that they have a purpose that is more in line with the district's purpose in terms of educating students, or using it maybe for some type of childcare facility, something that would be a benefit to the school. So maybe there's an outside organization that has really no school related connection that's not really going to help your school district very much other than the rental fees or the lease fees that they're paying, as opposed to maybe organization B that is saying, we want to come in and run a before school and after school care program that could really be beneficial to your parents. They can drop their kids off at the building before they head off to work, but before the school day starts. And the same thing is happens after school. The kids are able to stay there in a safe place until their parents can pick them up when they leave work. That may be a more beneficial use of the facility to the school district, even though perhaps organization B may not be able to offer as much as the other organization in terms of money, monetary value. There's other value that they may bring to the table that you are able to consider. Next slide, please. Wonderful. Okay, so we've talked about best value when it comes to leasing school property, and we just want to spend a moment here to talk about a distinction because sometimes it's a little bit confusing when we're talking about best value and best price for leasing versus selling school district property. When you're selling school district property, there is a heavier burden to try to get the best price, and there is more of a responsibility for the district to really get the best price for the property that it can, because that's a one and done situation. You're only going to be able to sell that property once, and if you don't get the best price for it, then you kind of miss out forevermore, as opposed to a lease situation where an organization may use your property for 6 months or a year, it comes back to you, and then you have the opportunity to lease it for a higher amount in the future. So there is an opportunity to raise that price with the lease situation because it will come back to the district each time the lease ends, but that's not the case with the sale of property, of course. So the law generally authorizes a school district to sell its real property when such property is no longer needed for school purposes. However, New York State's highest court has held that as a general rule, when selling property, the Board of Ed has a fiduciary duty to obtain the best possible price for any lawful use of the property. So this rule essentially means that the board cannot telescope a sale to a particular buyer, cannot direct a sale to a particular buyer based on that board's preference for a particular use that's proposed by the buyer. So in the situation of the daycare center, if they say, well, we want to buy the building, yes, that use may be helpful and nice to us, but we can't just go ahead with that at the exclusion of getting a better price at fair market value from another organization, as long as that other organization is going to use it for a lawful purpose. The particular method of the sale lies within the discretion of the board, so there's flexibility in terms of how a board goes about finding people who are going to buy school district property that is being sold. But whatever method is used needs to be designed to get the best possible sale price for this school district. Um, so regardless of the method that is used, the board must accept the highest offer if it's for a lawful use. Next slide, please. An exception to this general rule that we've talked about in terms of selling it for the best price is when that Board of Education is selling, conveying unneeded real property, so property that the school district no longer needs to perform its functions, to a public corporation. It can do that free of charge or for an amount that is less than fair market value, and that is incorporated within the law, Section 405. Let's talk about the definition of a public corporation under some of these entities that a school district may want to sell property to, in which it would not be required to get the best possible price. Next slide, please. So if it's being sold to a municipal corporation, meaning county, city, town, villages, or another school district, a district corporation, which is any territorial division of the state, or a public benefit corporation, which is a corporation organized to construct or operate a public improvement for within the state. Okay, so those are the definitions. Won't spend too much time talking about that because, of course, if your school district is selling property, this is going to require a deep dive by the attorneys with whom you're working. So you'll definitely be brought up to speed, but we're just trying to provide you with kind of the overview of some of the major parameters here. So we'll move on to the next slide, please. And let's talk about leasing school buses because we do get questions about this. And we want to have kind of a better understanding of what the guidelines are when a school district is leasing school buses. The use of school buses for purposes other than transporting district students. So other than your day-to-day, you have a bus picking up your district students from home, bringing them to school, bringing them back home. You're taking those students to school events, athletic events, extracurricular activities. To the extent that you are using it for other purposes, we need to always be careful that there is statutory authority to use it for other purposes. So the case here that is cited is Appeal of Jordan, and it's a case where many people would argue, hey, it seems like a really good purpose. It, is probably to the benefit of all. What's the problem with it? In a case like this, the school district was utilizing school buses to transport residents of a senior citizen home to a polling place to vote. And the Commissioner of Education said, no, that's not okay. The law does not allow you, there's no statutory authority for you to use school buses to transport people from an outside organization from the senior citizen home to a polling place to vote. The commissioner pointed to the fact that it could be used as a partisan purpose, but also more broadly, there are very specific categories that school buses can be used for, and if it doesn't fall within one of those categories, then it means it can't be done. In addition to the transportation of students to and from school and for school activities, the law currently permits, but it does not require, that school districts lease school buses at times when they are not needed for certain types of third parties. So you can lease to third parties as long as the buses are being leased at times that they're not needed for normal school purposes. But that is not required. It's permitted but not required. Next slide, please. The law requires that whenever a school district elects to lease or rent a bus, the consideration that's paid, the money that's paid by the lessee, may not be less than the full amount of the costs and expenses incurred as a result thereof. So, in plain English, when you're leasing school buses to other entities, it should not be incurring an expense to the school district. So, if they are not paying an appropriate amount that would cover the cost and the upkeep and the use of that bus, that means it's actually going to fall back on the taxpayers of the district, which is not going to be okay in most instances. We'll talk about certain little instances where that may not be the case. So, one where you would not necessarily need to get the consideration, the money to completely cover the use of the bus, is where a school district is providing transportation to certain children of students that are enrolled in the school district or BOCES program. And that is eligible for state aid. So to the extent that you may have students who have children and those children are taking a school bus to get to and from their own child care locations, that is something that can be done, and you don't need to get the best money for it. It doesn't have to be something that gets the proper consideration, and also where the school district elects to transport children to universal pre-K programs, it doesn't necessarily need to cover the full amount of costs and expenses. Next slide, please. In instances where a school district is leasing a bus to a third party, that third party needs to maintain insurance on the bus that's leased to protect the district from all claims related to personal injury or property damage. The lessee is required to carry fire insurance as well as compensation insurance on the driver of the leased bus. And also has to be collision insurance for the value of the bus. That all must be paid by the entity that is leasing the bus. Again, this should not be coming at the expense of the school district and the taxpayers. Next slide, please. Oop, okay, I think we're coming to the end. I do see uh, a question in the chat that goes back to what we discussed regarding uh, admission fees for organizations. The question was whether the rules would apply for admission charges by nonprofit organizations as well. So yes, the school district can require nonprofit organizations to pay admission or with the admission charges by nonprofit organizations. Okay, let me read that question again. Yes, so if a nonprofit organization is charging admission, um, let's think of any nonprofit organization. I don't want to name one in particular and single them out, but we have a nonprofit organization that is having some type of special event in your school building. They filled out your use of facilities form, and they're charging people to enter it and to use the space for that event. Uh, the money that they're charging, yes, would have to be used for an educational or charitable purpose. Now, they are probably already using their funds for educational and charitable purposes because they're a nonprofit organization. But of course, whatever they receive as a result of those admissions fees, just as with the for-profit organization, needs to be for educational or charitable purposes. It cannot then be funneled into some type of for-profit or private purpose. Okay? So I know that we're coming up towards the end of our time together. Really appreciate you all joining today, and I hope you have a wonderful day. Thank you so much. Take care.